Hi, I'm Jennifer Brown, editor of Canadian Lawyer In-House magazine, and I'm here today with Karsten Lee and David Thompson of Weirfolds LLP. In this edition of the Weirfolds Quiz, we're looking at franchise leasing agreements and the obligations owed by the landlord to each of the parties involved. Karsten, if I'm the landlord of a shopping plaza and my initial relationship is with the franchisor, what are the duties that I owe to the franchisee?
So the situation you're talking about is the normal situation where the landlord enters into a lease directly with the franchisor. So the franchisor is the head tenant, and then the franchisor then subleases the premises to its franchisee. So the franchisee here is the subtenant. Now, generally speaking, in those types of situations, the landlord does not have privity of contract with the franchisee subtenant. Notwithstanding that, though, there are some cases that have found that the landlord owes a duty of care to the franchisee subtenant. Now, when a duty of care is found to be owed by the landlord to the franchisee subtenant, the subtenant can, in essence, go directly after the landlord for any damages, notwithstanding what the position of the franchisor tenant is. So one such case where a duty of care was found to be owed by the landlord to the subtenant franchisee is the country style case. Now in this case, the subtenant franchisee entered into the sublease partly based on the site plan that was attached to the leasing documents. So they saw this site plan and they found that, hey, this is quite conducive to our business. There's a nice traffic flow into the shopping center. The drive-through flows very nicely to the access and egress points. And as you know, coffee, donut, quick service restaurants really rely very heavily on the sales that are generated through their drive-through. So in this case, the head landlord decided to unilaterally change the configuration of the shopping plaza and did not bother to tell the tenant franchisor and the subtenant franchisee. And obviously, because of the changes, the traffic flow didn't flow as well, and their business, especially the drive-through business, was impacted. So in this case, the court found that the head landlord did owe a duty of care to the franchisee subtenant, and because the head landlord unilaterally made those changes, they were found to be liable to the franchisee subtenant for damages.
David, if I'm the franchisor, what information do I need to share with the franchisee? And is that standard information applicable across the country?
No. To your second question, no. In Alberta, Manitoba, Ontario, New Brunswick, and PEI, they have legislation. Similar legislation. It's about disclosure. And you can use the Arthur Wishart Act in Ontario as an example. It's sort of the template. Alberta actually had the first act, but Arthur Wishart Act came after. So it basically, you have to give material contracts to the franchisee so they know what they're getting into. So that would include the head lease, so that let's say it's a lease site, like in this case, and then the sublease, and then any other real estate documents that went along with that. So if there are any easements, anything like that. So from a leasing point of view, you kind of have to give them the full picture. You don't have to give them the rent under the head lease, because that would be a bit too much information. But you do have to give them all the terms that they know they have to comply with. Because under the sublease, like in the country style case, you're taking through the head lease, so you have to know what you're doing. In the other provinces, most of them, not including Quebec, it's a common law thing, and it comes down to disclosure so that people know what kind of a deal they're getting into, and could there be damages if you didn't give them enough information. So in the Arthur Wishart Act, for example, if you don't give them that information, there's a statutory right to rescind, which means not only that they can get damages, but they actually get put in the spot they would have been if they hadn't done the deal. So it's actually, you have to give them back their license fee, you have to give them back the costs of having them move. Often people quit their jobs, so it's actually pretty onerous. So you've got to be very careful. You got to talk to somebody about what would be the material things I have to put in, but for sure it would be the head lease, sublease, any other real estate documents that would affect the tenancy there. Interestingly, in the country style case, the franchisor was also liable for damages with the landlord. So you got to be careful in these cases where if you're subletting something down, you've got to make sure they know what they're getting into.
All right, thank you both. For a more in-depth look at tenant and franchise relationships, please check out the August issue of Canadian Lawyer In-House.